welcome to AFB's second outreach of the year through the Outreach Committee. The Outreach Committee is charged with, well, doing just that, reaching out to practitioners, educators, and other members of the legal services community in both the tertiary, primary, secondary, and tertiary sense, to inform the community about what it is we do and be informed by the community as to what it is we do. To that end, we are going to discuss today the access to justice problem as it manifests itself in the criminal justice system. Our speakers today include a prosecutor, a public defender, and a attorney who works in legal services. So we will be looking at the impact of the access to justice gap in both the prosecution, defense, and post-conviction, and sometimes post-sentencing, i.e. after a sentence has been served, impact upon both criminal defendants and their families and the broader community. Our first guest will be Bernie. Bernie Zadrowski is a prosecutor at the Clark County District Attorney's Office in Clark County, Nevada. Bernie has been at that office for, was it 20 or 30 years and now 111 days?
30 years and 109 days.
109 days.
Who's counting?
But who's counting? Bernie's going to talk to us about the dynamics of the systemic problems we have with the access to justice gap, and focus on the disparities in criminal prosecutions that extend from the prosecution beyond sentencing. And we'll talk about the need for collaboration between the defense bar and the rest of the legal services community to address these disparities. So, further nonsense from me, Bernie.
I appreciate it, Michael. When we were talking, for those of you who were not involved in the meeting that we had where we came up with this topic, we were talking about what we might call this. And it was either Michael or Ken, I can't remember who, but I thought it was absolutely brilliant, the term you came up with, which was collaborative adversarialism. I ran that term by a bunch of folks here in the DA's office, and they're like, what, you just created a phrase? I've never heard that before, but it is so appropriate given the situation that we're in today when it comes to criminal justice. So thank you, by the way, for having me. I wanted to start out by telling you, and I think it's very appropriate, having been around in this office for 30 years now, how vastly different our approach to prosecution and to really our primary goal in the DA's office, our primary ethical consideration, which is to always seek justice. That is the prosecutor. For those of you who don't know, our job is not to seek convictions. Many people believe that. Our job is not to get the bad guy. I mean, in a very broad sense it is, but our number one ethical requirement as prosecutors is to seek justice. It literally says that in our ethical guidelines. And so most of the people that I've worked with over the last 30 years take that very seriously. But what is justice has changed in a broad way, at least in application, if not in theory, in the time that I've been here in the office. So what I can tell you is this idea of collaborative adversarialism is a relatively new concept, but one that has been embraced by our office, and doing a little research on it seems to be something that has really gained a lot of ground across the country. So as I said, 30 years, let me start out by telling you that back in those days, in the old days when I first started, we have our communication with defense bar, our communication with the public defender's office was rather minimal. We would communicate with the other side if there was some negotiation that was being offered. And it wasn't always the case. For many of the cases, and maybe even for most of the cases, we would reach out and we would make offers on cases that were coming up for a preliminary hearing or a trial. But many times, maybe 40% of the case, we weren't making offers on cases. And that was the norm. We've gone in that area 30 years ago to what we do now, where literally 100% of the cases negotiations are made. Now, I'm not talking about the gruesome murders. I'm not talking about the very brutal sex assaults. Some of those cases, there are no offers made. We're going to trial on those cases, some of them. But even those cases get negotiated, and there is an effort by the DA's office to reach out to make those offers. In the old days, we didn't do that. We kind of waited for defense attorneys. Hey, if you want an offer on a case, contact us and we'll see if we're going to make you one. So things have changed just in the very basic nature of communication in the DA's office with public defenders and defense attorneys. The other thing we had back then in the middle 90s and forward, we didn't really think about consequences of our prosecution beyond the trial. And we thought about and we prepared for, and we have a unit that dealt with appeals. But that was pretty much the only consequence we really cared about in the DA's office. There was no concern on the DA's part about collateral consequences. Now, everybody knows since in the years in between, we have Padilla now, and collateral consequences are a major concern. But in the DA's office, we were concerned about making sure that our case was tight enough to stand up on appeal. That's changed. And a lot of that has changed not only by force, because we had to change in the DA's office, but because it's a different outlook on prosecution now. We care about collateral consequences. And of course, the driving force there is immigration. And so we have to address it because in a place like Las Vegas, where so many people come and go, we have to be prepared for that. So things have changed in that regard. I think I probably need to make another point before I get going any further, in that I've worked in other DA's offices. I worked in Colorado when I first started out as a DA in Colorado Springs. And things are vastly different here in our approach to justice in Las Vegas, and primarily because, you know, we're known as Sin City, right? Anybody who's knows anything about Vegas, we are Sin City. We have not necessarily a toleration for crime, but we've got a history of very big personalities that were in the gambling, the prostitution, the drugs, the criminal trade, if you will. And because of that, because we have seen it all, and because it's been on such a large level here in Las Vegas, and because of the nature of our town, it's a gambling town where people lose it all and they bounce back. We have I would say, a toleration for not the crime, but for second chances. Let me put it that way. We root for the underdog here. It's a weird thing. We're all about second chances in this town. Everybody who knows the history of Las Vegas knows that. People come out here, they go broke, and then they find themselves back on top of the world. I think about Vegas every time I think about moving here and how I got here. I think about that old Frank Sinatra song, the That's Life. You know, I've been a puppet, a pauper, a pirate, a poet, a pawn, and a king. And when you lose and you get right back up, that's the nature of Las Vegas. So many of us come here for second chances. So many people in professional life, et cetera. And all of this, the reason why I bring this up is we're a different town when it comes to justice and our overall feeling about getting people second chances. It's very prevalent here, which is not necessarily the case across the country. But anyway, I digress. Let me talk about the way things are now. and how different they are compared to when I started 30 years ago. So we have now, I'll give you a few things that I've been personally involved in. We have a program, many places have this, Hope for Second Chances. I hope everybody's familiar with that. If you're not, know that it's a program that was started privately, that gives people who really are either at that point where they're going to be going to prison, either habitual prison, they're going to be gone for 5, 10, possibly the rest of their lives, on cases that the case itself is not that bad, but because of their criminal history, 3, 4, 5, sometimes 10, 12 prior felony convictions, it's time for them to go to prison. But the charges themselves and the nature of the offense, how they were committed, requires that we take a second look at whether or not this is the kind of person we want to put in prison for a very, very long time, and to commit those resources for somebody to be locked away for such a very long time. And this program was developed for us to take a look at that. Here's what's different about it. It's not the private sector. It's not former or ex-felons driving that program. It's actually our office. It's actually the district attorney's office. We actually have right behind me in a wall, but right behind me, a person who is the coordinator for Hope for Second Chances. She's a career prosecutor. So the district attorney's office not only is participating in it, but we're actually a driving force, keeping that program together, searching out those cases that we prosecute to find those nuggets of people that we believe are going to be able to take advantage of this last opportunity to get them on the straight and narrow and to make them productive members of society. So that's one thing that is a huge difference, and it's been very impactful. As a matter of fact, we just had a meeting last week, which we attended, and we were able to congratulate all these graduates from this particular program. That's a huge one. The second one that we deal with a lot is we have this requires a little bit of a historical understanding. Vegas has had a culture and a persona that a lot of people across the country and across the world picture. People think that we live in casinos, hotels, as the people that live here, and we spend all our time down at the casinos. I haven't been to a casino in probably on the Strip in probably 7, 8 months. And before that, it was probably 7, 8 months before that. So we don't live in casino hotels. Las Vegas is a thriving metropolis, 2 million people here. And so, but the lifeblood of our community, of course, is the resorts down on the Las Vegas Boulevard. So a funny thing happened right around COVID. We started seeing that people were going on to TripAdvisor and talking about what a filthy place Las Vegas has become. We tried to market ourselves for a period of time that we're a family place, not just gambling, but also family. And we started seeing, because we have, especially the resort associations, they pay attention to this stuff. TripAdvisor, the negative comments, it's a filthy town. You have to step over homeless people in order to get in and out of casinos. The drug activity, the drug sales down on Las Vegas Boulevard, out of proportion. The number of gun crimes that were occurring not only on the Las Vegas Strip, but spilling into the actual casinos themselves became unbearable. And so the Nevada Resort Association, which is the association where every major casino belongs and contributes to our community, decided we're going to do something different. And this is a private organization that partnered with the district attorney's office, our office, the county manager, the county finance people, and the public defender's office in order to clean up Las Vegas. And so we are, in essence, involved in this collaborative adversarialism with the public, the private sector, in order to try and clean this up. Now, you're probably thinking, oh, so you're going to go arrest people who are homeless. You're going to make it more criminal. And you're going to put people in jail because they've got nowhere else to go. No, that's not what's going on. As I said, this is a partnership. And what we've done is we have come up with solutions, wraparound solutions. services for those folks. Let's face it, they're there, and the crimes that they commit aren't your typical crime. We're not going after the hardcore stuff, but we also have to recognize that the casinos being our lifeblood, we got to get people here. We got to get tourists because they keep our community growing and safe and all of that. And so we've come up with this solution, this collaboration with private entities, the public defender, and the courts to clean it up. And so what we're doing, much like the San Antonio project. I don't know if anybody is familiar with the Haven for Hope program, but it's a collaborative adversarialism down in San Antonio where people get together, all the partners in the community, and we offer solutions. We send people when they get arrested from the Strip, we send them to a location in town rather than taking them to jail, where they get services. There may be court services. There may be rent, food, a shower, counseling. It's huge. And it's not necessarily being funded only by the county. It's also being funded by the Nevada Resort Association. And the courts have now created what we call a community court. And we take people off the Strip who get arrested, not just on the Strip, but all over Las Vegas. And we rift them to the community court. We look at their cases here in the DA's office. We have people who are dedicated to reviewing these cases to see if it's an appropriate case to send to community court, where they're going to be, watched by the court. They're going to be watched by the private entity, by this umbrella organization that's going to try and find them services and try and get them out of the criminal justice system, so that we don't have this ongoing problem of recidivism. Let me finally talk about one other project, which I think is pretty fantastic. And it's kind of taken this idea of deferred prosecution to a new level. We actually have this program that we started several years ago called the Conviction Integrity Unit. It's not the public defender. It's not the state public defender. It's not the defense bar that's looking at whether or not the DA's office is doing it right when it comes to prosecution. It's actually a deputy DA in our office that is looking at these things and reporting to the public so that we can be, so we can stand in front of the community and say, we're only prosecuting the cases that need to be prosecuted. As a result, and I'm very proud to say, of that deputy DA who looks at conviction integrity, I can tell you he has very little to do in this office. It's fantastic that he's not busy, all right? Because he's not so busy, we have also tasked him with this program called Project Redirect. This is the DA's office taking a proactive look at cases before they ever get filed to see if we can offer counseling services, if we can make sure that we supervise them, these cases, low-level offenders, to get them before they ever get into the criminal justice system. And it's a pretty fantastic program. I think it's very successful. It's rather new. It's only a couple of years old, but we're getting a lot of people out before they ever get into the system. Now, imagine for a dinosaur like me who came into the prosecutor's office 30 years and 109 days ago. Going into this, I'm a prosecutor. I was never a Boy Scout when I was young, so I'm not your typical prosecutor to begin with. But going into that system and coming out of a system in a relatively short period of time, 30 years is not that long, into a system where we're not just looking at how many convictions we can get, we're still maintaining our ethical duties of seeking justice. But this concept of justice has really, really changed in its application. And I'm very proud to say that, and I'm a creature of habit. I'm a pretty conservative guy, but this new approach to justice, as I've gotten through the system, recognizing that we have to do something about it, the old ways aren't always working. I'm very happy to say that this is a world that I really like. I like what we're doing. Sure, there's lots of things that we can fix, and we need to tinker with on the way. But it's really become one of those jobs that has really expanded to where we're looking at it from a different angle, and we're looking at justice in a different way. So that's what I have to tell you. If you have questions or anything, I'd love to talk more about it. Find this whole concept really, really fantastic and interesting. And if there's anything else I can say, if you have any questions, please let me know.
Thank you, Bernie. And we will have opportunity for questions after our last speaker.
Yeah.
During our preparatory meeting, I had mentioned that this entire approach to the criminal justice system reminds me of a late 20th century philosopher out of Harvard by the name of John Rawls, who wrote probably one of the most influential books on social and political philosophy of the 20th century, Justice is Fairness. He argued that inequities in any social system, be it economic, political, justice, et cetera, are inevitable because humans aren't homogeneous in any population. And that if there are inequities in the system, they should advantage the least advantaged people in the system, because the advantaged people, well, they're already advantaged. And it strikes me that that's perhaps not consciously, but a driving force behind the concept of collaborative adversarialism. And it was Ken Huck, our next speaker, who introduced us to the phrase in reference to a text that he has recommended. Ken is a federal public defender in Eastern Texas. And prior to that, spent almost 2 decades as a prosecutor and a criminal defense attorney in the private bar. So Ken is intimately familiar with both sides of the coin in the criminal justice system. Without, again, any further nonsense from your handsome host here, Ken Hawk.
Thank you so much. I appreciate you guys, and I appreciate everyone here. I'm going to talk on a meta level today, not just the nuts and bolts, but the broader picture thinking. And I'm going to start with the story. And the story surrounds me in the federal defender's office, walking into the courthouse. We're greeted by courtroom security officers that man the front desk, and I know them all real well, and they know me all real well. And as I walk by and they say, what's going to happen today? And I usually make some remark about, well, there's no doubt if I'm involved, someone's going to prison today, or some remark that I can make a laugh with. And as we come back out of the courthouse, they ask how'd it go. And I always made this weird flippant phrase, this concept of, well, we're all on the same side on this thing. And I've said that for years, that prosecutors, defense lawyers, judges, we're all on the same side. And it never felt right to say that because of the concept of adversarialism, and we fight hard as defense lawyers. When I was a prosecutor, I fought hard as a prosecutor. So I knew there wasn't something just perfect about that construct. And about 6 months ago, I wandered into it, and that's what I want to describe. I'm going to tell you exactly how we implement it in the Federal Defender's Office in the Eastern District of Texas, understanding that every district in the country, whether it's federal or state and local, we're all different, and we're staffed by different people with different histories and different sociologies. I'm going to talk about our Eastern District of Texas, and it's so heartening to hear Bernie speak because I think they're probably 20 years ahead of the Eastern District of Texas. This is where we want to get to. I always make the joke that Tyler, Texas, which is where we are, 90 miles east and 25 years behind Dallas. That's what we always tell folks. And I was listening to a podcast on the road one day, and I heard Simon Sinek. And for those of you that know Simon Sinek, he's a business philosopher, and he talks about social kindness and the bigger and broader issues. And he came up with this construct in the business world that he said applies everywhere. And I'm going to introduce it to you in the justice concept. He talks about the golden circles, and imagine the Target department store or just a Target, these concentric circles. And on the outside is the what. What do we do? What are we doing? And when you get right toward the next level, it's how do you do it? But the middle target, the actual bullseye, is where the rubber meets the road. That's where our life's mission is found, and that's the why are we doing it? And when I heard him describe that, I immediately said, I can plug this into criminal justice. I know that I can. So I say, what do I do? Well, I represent criminal defendants charged in federal crimes before federal district courts in the Eastern District of Texas. Okay, there we go. That's what I do. How do I do it? Well, arguably, we're supposed to have better training, better resources, better adversarial skills, specializations in various crimes and related offenses, being full-time federal criminal defense lawyers for the Eastern District. That's how we do it. We're just more skilled because of the repetition, because of the experience that we have. So that's how we do it. So now I know what I do and I know how I do it, but the question becomes, why am I doing it? And I think that's the key. And I came up with this concept that I just try to figure out, what is my why? And my why is what the criminal justice is about: accountability for criminal conduct against the backdrop of fairness defined by the Constitution. That's the why. That's why I'm doing it. That's why Bernie's doing it. That's why judges are doing it. We're all really on the same side if we just take that half step back. Does that mean we get along all the time? No. Does that mean we fight fiercely? Sure. But it also means that if we keep our eye on our collective why, what we're trying to achieve here, I think the system works better. It's a better life. It's a better outcome. The concept of justice is furthered. And so I took this, and so I've been now thinking of it. And I was sitting in chambers the other day before our hearings in our little district. The magistrate judges want to know what's going to happen in this hearing. So we come in chambers and we talk to the magistrate court. And I saw a book laying on her table that had the concept of collaboration and adversarials. And I said, that's what our district is. Our little federal district, which is huge by space, but small by people. We have this notion that's been built over the last 30 years by people that came before me of collaborative adversarialism. And it really is an amazing phrase, not because of the phrase itself, but what it means. And so I want to talk to you about our rubber meets the road. Bernie, you've got a lot of collaborative adversarialism in your burg. In the Eastern District, we do a little bit differently. Here's what we decided. Our original federal defender appointed by the Fifth Circuit, 1994, named Pat Black. And Pat Black was a well-respected lawyer. He was a prosecutor. He opened the office, and he and his first assistant is going to retire at the end of the year. They said, we're going to do it differently. We are going to isolate the battlegrounds. That's what we're going to do. We're going to find the it in every case, and we are going to fight fiercely on those battlegrounds. And everything else we're going to work out. We are not going to waste time. We're not going to file pretrial motions just for the sake of filing pretrial motions. You're not going to see a suppression motion in every case. You're not going to see us filing motions to quash that are ridiculous. You're not going to see us filing motions on behalf of a defendant alleging prosecutorial misconduct, because that's the latest trend. We're going to find the battle area and we're going to do it. And that's where we're going to fight. And if we choose that path, we're going to build a trust. We're going to build a trust with the courts. We're going to build a trust with prosecutors, that they know that we know what we're trying to achieve. And I think that's the key word, trust. It does take trust to achieve this. It doesn't happen overnight. There are lawyers in our community that nobody trusts. And you guys all know lawyers that nobody trusts. But if you know that your word is what it is and your methods are honest and they are in integrity with the facts, and when you say something, people know they can count on it, that's those first few baby steps. And over time, I remember when I first joined the Federal Defender's Office, it was 2006, and about 2007, I had a suppression issue. And we talked it through. And two things happened. One, I filed the motion to suppress, and the court immediately had their attention. The Federal Defender's Office filing a motion to suppress, this must be something. This must be something. We need to have a hearing. And we heard that kind of language. When we speak, it means something. And the second thing, which was really on the prosecution, the federal prosecutor called our office and we talked it through. He just dismissed it because I'm not going to make you have a hearing. You're right about it. No ridiculous fights. No trying to win for the sake of winning, just the concept of finding the right thing. And that's what we tried to do. And we built that philosophy, and it takes judges trusting the participants. It takes the participants trusting each other. Now, I talk about this concept and I say, why is that important? And how does it help in access to justice? Here's why it's important. because in our district, most of our arrests come from the state authorities. And then the cases themselves are adopted by the federal government. So we'll see somebody that's picked up in our little county and they're arrested and they sit in jail. I'll give you a parenthetical about our county here in a few minutes, but they'll sit in jail for a period of time and then the feds will adopt it. So we've got a few months in state custody, then they're pulled into federal custody. And so now we have corresponding and correlating charges. We've got state charges and federal charges, and we have this notion of, well, it's my sandbox or it's your sandbox. And our office takes a broader approach, and that is it's the justice sandbox. We try to deal with every part of a defendant's life, good, bad, indifferent. And we try to engineer the outcome of a case so that we get what? Accountability for criminal conduct against the backdrop of fairness as defined by the Constitution. Some recent examples, and they're valuable examples, and they were done by agreement completely. Young lady in state custody. She's in state prison in the state of Texas, and she's riding a 5-year sentence. Well, she was on federal supervised release, which is kind of a probation after you're out of federal prison. So the feds went and got her, and they said, you got to come clean up your federal supervised release because you broke your supervision by committing the state crime. So we pull her into federal custody and we meet this girl. And what we find out is she's been in state prison for about a year, year and a half, and it's summertime in Texas. And for those of you that don't know, it gets hot, maybe not Las Vegas hot, but real hot in Texas because we had humidity. So it was about 106 degrees outside. It was about 95 to almost 100 degrees inside. Why? Because Texas prisons have no air conditioner. And their water in their prison unit was off except for about 20 minutes a day. And the kitchen wasn't running. And it was just right at subhuman conditions. And this girl looked at me through tears. She said, what can I do? I don't want to go back to state prison. I don't want to go back to state prison. And so what we did was we engineered a result. Here's what the result was. The court agreed. The prosecutor eagerly joined in. The answer was this. Let's just keep her in federal custody for another 90 days until the weather cools off. She's going to have to go back to state prison anyway after this revocation, but let's keep her in the local jails with air conditioner, with services, with resources, with water, for goodness sakes. And we're not going to send her back till it's cool. And that's what we did. And there wasn't even a second thought about it. It was the concept of looking at the whole person, trying to figure out how we make justice match the facts of the case. I met for the first time Erica a couple of weeks ago on a phone call, and her work, which I can't wait for you to hear, it's more than valuable. It's the second half of what we deal with directly. When we talk in our federal system about the broader access to justice, one of the places the rubber does meet the road is in the Federal First Step Act. When you go to federal prison, there are methods by which you can increase good conduct time, which is another way of saying you can decrease the amount of time you actually spend in federal custody. And there's ways to do that. The First Step Act got passed in 2018 and expanded the ways to do that. And what they basically said was this: if you take classes and they're designed toward reintegration into the community or the betterment of yourself, whether it's life skills, drug rehabilitation, any trade, certifications, college courses that you take in federal prison, we're going to increase your good conduct time on a certain type of offenses. And there's a list of offenses that exclude you from consideration for eligibility for First Step Act consideration. So what do we do on our side? We pay attention to the charges. If someone's charged with a 3-count indictment and 1 count is a disqualifying offense and the other 2 are not, we're going to figure out a way. If the person's guilty, needs to plead guilty, to plead them guilty to the count of conviction, which doesn't disqualify them from the earned time credits from the federal prison system. It's just basic common sense. How do we expand the opportunity for a defendant to get back out and be successful? Because we don't want to win, like George Patton said. We don't want to win these little battles. We want to win the whole damn war. And that's what our goal is we got to get these people back out after being held accountable in a position for long-term success. It's not always easy to do, but if we pay close attention to what we're trying to achieve, and we've got prosecutors on our side that understand that, yeah, we need to change this charge. It's the right thing to do. And in our little district, we do have prosecutors that fight just as fiercely for lower sentences on a defendant that earns it as they do to bury the guys that we represent that absolutely richly deserve it, because we have that population as well in the federal system. So I'm going to wrap it up this way. Every process starts somewhere. our process in the federal system in the Eastern District of Texas is behind Bernie's. It may be ahead of other communities. It's discussions like this at the national level of people all across the country listening to different ways that plant seeds. We're on the way to where Bernie is. We're not there yet, but what we're not is where we were 25 years ago in the Eastern District. We had books and movies written about our little county, only about corruption, not about justice. And those winds are blowing differently and the shift is being made. And it's discussions like this that I'm grateful to be a part of that helps us get these changes effective. So thank you all so much.
Thank you, Ken. After listening to your talk, I'm now reminded of another philosopher named Aristotle, who said that the purpose of human existence, either individually or collectively, is eudaimonia, or well-being. And the justice system seeks the well-being of the community, which involves the well-being of victims and criminal defendants. They're part of the community. And then he would further say that in order to accomplish this, you have to follow something of the golden mean, which is to become a person who not merely knows what the good thing to do is, what eudaimonia means, but to act it out. That the good actor does the right thing for the right reason at the right time. That's the why. It's why we are involved in the justice system, is to, at the right time, under the right circumstances, seek the right outcome. And we accomplish that through prudence or practical wisdom, what Aristotle called phronesis, which roughly translates into prudence. And these are prudent steps. Why are they prudent? Because they increase the well-being of the community, including all the individual members. And somebody here who works on a day-to-day basis in furthering the well-being of her community is Erica Brandt, our next speaker, who works with a legal aid office. And I got to look at my notes. I forgot which state it is that it's in the southeast.
Pennsylvania.
Pennsylvania.
It's
Thank you.
Pennsylvania. Yeah, the
As we
southeast
talked about
Pennsylvania.
Jim Thorpe, Pennsylvania. That's right. This old brain, it's not getting any more flexible. So without rambling on with my nerdy philosophy nonsense any further, I'll turn this over to Erica Bryant.
My pleasure to be with you all. Thank you so much for having me. I'm Erica Bryant. I'm Director of Community Engagement and Training at Legal Aid of Southeastern Pennsylvania. But what I really do and have done for the last decade, actually Sunday is my 10-year anniversary, but who's counting, is help clients who are dealing with the collateral consequences of having a criminal record. So largely we help clients with expungements, with pardons, and we'll talk through all of that in some detail. But for framing purposes, I think Ken and Bernie really went through some great and exciting innovations and improvements, and you can sort of see a change in philosophy, right? There's a reason that Michael keeps going back to philosophers, because there has in the last 5 or 10 years really been quite a rewrite, a reevaluation of how we are running our criminal legal system. And unfortunately, what that hasn't captured is helping folks who were impacted by that sort of old and problematic philosophy, right? So folks who maybe now would be offered a diversion program 10, 15, 20 years ago didn't have that same opportunity. And so that means they are still that record is still impacting them today, right? We can look at states that have legalized marijuana, but didn't go back and affirmatively clear the records of everyone who had marijuana convictions, right? That leaves millions of people still in that situation, even though we've made all these policy decisions to change things. So that is where I hope my work gets to come into this discussion. The other thing that's not captured in all of these innovations, which are, legitimately great and exciting, is what happens after the criminal case ends, right? A criminal case happens during one very specific moment of a person's life. And then that record will be with them forever, regardless of what happens next, right? If somebody goes on and does a lot of work, gains a lot of insight, furthers their professional ambitions, they may be a very different person who's going to make very different decisions going forward, but that record is still with them. Right now, about a third of people in the United States have criminal records, about a third. So that's quite a lot of folks. And of course, I don't think any of us would say that having a criminal record necessarily means that you are, not trustworthy in all circumstances. That would be silly, right? I have a traffic ticket. I am one of the 1 in 3 with a criminal record. And even the Bar Association of Pennsylvania agreed that I was okay to be a lawyer. When you look statistically at how long a criminal record has predictive value, right? How long after that conviction is the individual more likely to catch a new case in the future as compared to someone with no record at all? And the statistics are complicated, right? We all know how many variables there are. Of course, controls are a problem. But there is a great study out of Carnegie Mellon, and based on their findings, they found that misdemeanor convictions have a predictive value for only 3 to 4 years. So if someone remains free of new arrest and conviction for 4 years after a misdemeanor conviction, they are no longer any more likely to catch a new case in the future, as opposed to someone who had never been arrested or faced.
Sorry to interrupt, but there is a meeting that starts.
I'm literally giving a Zoom presentation right now. Can we pause for one moment so I can apologize to the folks who are on Zoom? I'm really sorry. So I'm having this presentation from a conference, and I thought I was in a room that was preserved, but I am just being informed in this moment that I need to not be in this room anymore. I'm so deeply sorry and embarrassed. I'm so sad that my friends, Chris, I asked, it was a whole thing. Goodness gracious. All right. So I think I have no option other than to step aside, or else you're all going to start hearing and watching people fall in the background. What a situation. All right. So I'm going to step away. I'm so sorry. I'm going to have to ask somebody to fill for a moment. Oh, okay. They worked it out. I can stay. Thank you. Okay, so now we just have to deal with the fact that my anxiety has spiraled wildly. All right, refocus, channel those courtroom skills, right? Okay. So predictive value for a misdemeanor, 4 years. After that, we are only dealing with prejudice and stigma. That is the only reason that a misdemeanor conviction would be relevant 4 years after they've completed their sentence if they have no new arrests. Surprisingly, the redemption point for felonies is longer, but not that much longer. It's 7 to 8 years. After 7 to 8 years, statistically, no more likely to catch a new case than if you had never had a record in the first place. Given that, I think the import of helping people move beyond that irrational stigma is vitally important, right? 1 in 3 people in the United States might have a record, but they aren't blanket untrustworthy to rent an apartment, get a degree, a professional certification, or hold down a job, right? And so that means there's a huge role for civil legal aid and for educators with access to students who are trying to build skills to work together to try and address it. At this point, 1 in 3 Americans, we're talking about more than 100 million people, right, who have records, who therefore could benefit from help mitigating their collateral consequences. That's a huge need. My personal client population, even when you reduce it to figure out the folks who are financially eligible for legal aid, which is a very low threshold, my potential client population in 4 counties is 250,000 people. Whew. Right. So that means there is huge opportunity. And so, I want to talk about how we have been able to partner with paralegal studies students at 2 of our local community colleges to help address that need and do something to close the justice gap. So, all right, let's talk about that. And thanks for the kind messages about my recovery. I really feel like I am back in the swing of things, but that was a rough go. All right. So we have been working with Delaware County Community College, with Nilofar's program, and with Bucks County Community College. Chris Simcox is also on the line. So both of you feel free to chime in if you've got stuff to add about this from the school perspective or the student perspective. But one thing we do invest in heavily is running outreach events and clinics. As a legal service provider, if I wait for clients to find me, by definition, I am failing at my job, because it means I am only helping people who have the resources to know that legal aid exists, to think that there might be a way to ever crawl out from the hole of having a criminal record, that they're worthy, that they're trusted, all of that. Plus, not to mention, they need to have a phone to reach us. They need to be able to navigate any language barrier that they might have, right? Once they get to us, we have interpretation available. But whether they can get to us, there are huge language access barrier issues. So because of all of those structural challenges, we take very seriously the responsibility of leaving the office, right? Trying to reach people through networks that we wouldn't necessarily have. And so that's why those partnerships is so important. We partner with lots of folks, not only the community colleges, but one of the partnerships I am proudest of is with the community college, because it works not only to help build the skills of the paralegal studies students, but it also simultaneously helps to remove barriers for the entire community college community. I couldn't avoid saying community twice. Right? Other students who might be pursuing degrees in nursing or finance or early childhood development, anything where we know there's going to be an intensive background check process. We've got folks who are already doing everything we would hope for them to do, right? Go back to school, get an education, pursue a career. So being able to just remove one of their barriers is deeply satisfying. When you think about it from a development perspective, right, you can see how putting those skills and that service in the community has all these great tendril effects. Not only that, but very selfishly, any legal aid organization that is being funded through the Federal Legal Services Corporation is required to leverage pro bono volunteers. All of our fabulous paralegal studies students are pro bono volunteers. So if any of you are listening to this and thinking you might like to see what opportunities exist for your local students to partner with legal aid organizations to help staff their clinics or outreaches, or if you want to see about starting an expungement clinic on your campus, I will make sure that I put a link in the chat to where you can find the civil legal aid provider in every county in the United States, from Hawaii to the Virgin Islands. There are partners available, and we have to do this work. Also, we found it to be an extremely effective way to recruit paralegals who perhaps need to do internships as part of their program, right? They volunteer for us at the clinic, and then sometimes that feeds into their internship. And then simultaneously, sometimes it feeds into employment. I think we're all in a phase where recruiting is hard. So that might be another way you could sell this to your potential partners. Plus, of course, you'll reach clients they wouldn't otherwise never be able to find. And also your students will help increase their capacity. So it's a great model. The way we run things is that we advertise to the community college for paralegal studies students who are interested in volunteering. Then we run a training for them, usually 3-4 weeks before the clinic. We aim to have the attendees, the potential expungement clients, registered before the training. That way, at the training, the students find out who their clients are going to be and they can prepare for those meetings in real time. I think the students generally have a great experience, and we train them on everything from how to find a case, how to analyze a case, and then also we prepare them to have that client meeting that they take point in running. So the students are developing real skills, all of which will be transferable, even if they never touch a criminal case again, right? Because learning how to have that client conversation is really important, and I think very difficult to facilitate those students getting that experience.
Thank you, Erica. And yes, great recovery. Absolutely fantastic recovery. You stuck that landing. There's nothing like unflappability as a skill for a litigator. So, one confession, 2 quick anecdotes, and then a thought of my own before I turn it over to questions. First, beginning with Chris Simcox, who apparently has a clone or 2 or 3 because she does so much work in so many different capacities. The confession, I too have a criminal record, a traffic conviction or 2. And if I owned a sports car again, I would probably get a couple more. So.
A traffic ticket? Oh, hold my beer.
Yeah, I know. Time to clutch the pearls. The anecdote, well, it just left me actually, just right out of the brain. But here's the thought that I had, is that one of the things that we should think about, and I've tried to do as an educator of undergraduates in the legal studies area, is to talk about the why it is we do what we do. And I think I will be running with that phrase, collateral adversarialism. And why it is we do what we do is because we want to achieve eudaimonia. We want to achieve human well-being for ourselves, for our clients, and for our community. And that does not necessitate, and as a matter of fact, counterproductive to think that that means winning from your side at any costs. Everybody loses when everyone wants to win. Now, I say that and anticipate not winning tomorrow as University of Oklahoma faces the University of Tennessee, where our former star quarterback who took us to our last national championship all too long ago is now the head coach. So Chris Simcox has a question from Southeast Pennsylvania, not too far away from Erica and Nilafar.
Before I do that, Michael, I just want to say that anybody that's on the call who hasn't tried to make any connections with their local legal aid offices, there is so much good work that we can do and that our students grow from. I am new to this. I took it off of Nilafar and we ran with it, and my students have just thrived under that program. And thanks to Erica, their training's been, so in depth. And so they've learned so much. So I would highly, highly, highly recommend to you to take advantage of that partnership and try to get in there, because I think that's a way that students can feel that they are helping that access to justice issue, and they also are learning immensely. My question was off of, I think, Ken Hawk's speaking, that I just said in that collaborative world that you are entering into. For those that are defense attorneys, how do they sell their client on that? Because I find that whenever I collaborate with anybody, if it's the other side, my client is immediately suspicious of me, and I will no longer have a client. So I want to be collaborative, but I think it's extremely hard position to be in.
I think that's a really great question, and I'll confess that I've seen that. I've seen that in action in my district. I've seen defendants, our clients who, why aren't you fighting? And candidly, it takes a lot of work. And I know all of you who are defense lawyers understand the effective communication with a criminal defendant. It's hard, especially in the federal defender's office. Oh, you're one of those court-appointed lawyers, the public, there's a lot of phrases about how bad it is. But the question becomes, how do they want this to end? And all of them want the best outcome. And when we carefully explain to them that it's not about being friends with prosecutors, it's about working with them to find the right result. And if we can show them our results, which I'll take our dispositions in our little district over anyone's in the country. And part of my job is to travel the country and talk to other districts. And I hear how they do things, and it just makes me sad because criminal defendants just get crushed in districts where all they do is fight about everything. So when I explain to our guys, look, you're going to see some things you're not used to seeing, but watch me. And I'm not going to tell you to trust me. I'm going to show you can trust me. And we're going to see how this thing comes out. And it took a while to get that reputation among the people in jails. And it's really rewarding if you continue to work that way, Chris. For me personally, oftentimes the people that I meet in jail at initial appearance, like, oh yeah, I've heard of you. I want you. I want the federal defender's office, because they've heard of us already. And that's after arrest, but before we ever meet them. And that just comes from building that dynamic over time. So yeah, I validate the theory, the fear. It's completely valid, and it's not easy. But I promise you, when you tell them the results are going to be better than it would be if you fought over stupid stuff, they'll go, okay, let's do it that way. And that's just been our experience.
Fight smarter,
Thank you.
not harder.
Yeah, that's right, Michael.
And this arises in the civil justice system as well. We've any of us who've practiced in civil litigation have had clients who want us to fight no matter what. And again, it's not productive. It's not the way to accomplish justice. It's a way to accomplish a lot of billable hours.
If I can throw something in there, this is Bernie. And Chris, that's a great question. I see it all the time. And part of the problem, as I see it, is training, or lack of training, and really thinking about what's best for the client. Now, again, you're talking to a prosecutor. I'm not a defense attorney. I will be in about a month. But the problem is that people get into this checklist mentality. I got to do this. I have to do this. I have to do this, because if I don't, it's ineffective assistance of counsel. And that I have a lot of experience with, because I have to obviously, in essence, defend it, the prosecution anyway, and say, no, this is not ineffective if you didn't take this step, given this overwhelming evidence over here that exists against client. Now, obviously, when the evidence isn't overwhelming, then it becomes that's a whole different issue. But yeah, I see that all the time. And I see people, I've even had friends of mine in court say, please, I know you're a friendly guy, Bernie, but please don't let my client see you and I, cutting up before court starts or anything like that, because they get the impression that somehow we're in collaboration to put them away, those kind of things. I see that all the time.
Yep.
And that training, I think, should begin with the idea that Ken pointed out from the text that had inspired him to think this way, that the why is the critical factor. And it's thus a cultural issue within the justice community that should start, in the earliest stages of legal education, whether that be undergraduate or professional legal education. The why is justice, not winning, justice. And when you have the right aim, it's much easier to do the right thing at the right time. That brings us to the end of the hour. We've got
Wow.
60 more seconds. Do we have any more questions from the audience? Nilufar.
No question. Just wanted to, I was just thinking that how do we get this idea, this novel idea we just got of the term we got of collaborative adversarialism? How do we get that into the law schools? It seems that's where it needs to, we have an adversarial system. We're not going to get away from it. But if we could implement some of those concepts and policies and theories at the school level, then you are training your young minds to think that way, as opposed to, people at our stage of life. I mean, not that we can't learn. You can teach old dogs new tricks, but new dogs, new tricks would probably work better. And the other the other thing I wanted to just mention is I am one of the community colleges that Erica works with, and it is like Chris, I can vouch for it that it's a wonderful opportunity for your students, both in terms of experience and job opportunities, and also this idea of access to justice. Students love it. Even if they go and work for a for-profit organization, they, at the back of their head, the pro bono, the nonprofit, they value their contribution to the society as a whole. So I love it. My students love it. We can't recommend it enough. So reach out to your local services, whoever they may be. If not Erica, there is another Erica out there, and you will not be sorry. Thank you.
Thank you. Well, I'll leave you everyone with this thought. Be the change you want to be. We teach undergraduates, many of whom go on to law school. Increasingly, we're playing a role in pre-law school education or pre-law education. And if we say and walk with the idea in our hearts that the why is justice, then we can affect a cultural change which begins to manifest itself or has begun to manifest itself through the work of legal professionals like Bernie and Ken and Erica. So thank you, everybody, especially to our guests for sharing their time with us and for loaning a room from a conference, which I don't think is a crime, but I don't have a license to practice law in Pennsylvania. Good day, everybody.
Thank you all.
Thank you guys so much.
Thank you. Thank you for being here.